I've spoken previously about how the strength of a legal argument depends on the strength of the precedent upon which it relies. I want to go into a little bit more depth here about the nature and hierarchy of legal precedent. Now, our system of precedent comes from the English common law, and it's normally traced to the work of Sir Edward Coke, who compiled a 13-volume, essentially case book called The Reports that became very influential among judges. As a lawyer today, our system of precedent seems normal, but upon further reflection, it's actually a fairly strange way of doing things. I realized this when having to explain to a client that their best argument is foreclosed because someone 100 years ago, before they were even born, faced a similar situation and the court decided that case in a published opinion. But of course, the system of precedent has a great deal of advantages. It provides continuity, it provides predictability, and over time, at least within a jurisdiction, it provides a certain uniformity as to how the law is applied. Regardless, it's the system we have. Generally speaking, precedent comes in the form of a vertical hierarchy. Cases from the United States Supreme Court carry the most weight, circuit courts below them carry a little bit less weight, and then district courts below them carry even less weight. But there's a lot more nuance to our system of precedent. Let's take a closer look. District courts rule on a variety of matters, but don't usually issue written opinions like you'd find in a casebook. And even when such written opinions do exist, higher courts generally don't pay much attention. But I want to qualify this general rule in three ways. First, if you're in district court and there's a district court opinion, particularly in the same jurisdiction where you are, it can carry great weight because the district judges often know each other within a jurisdiction and they respect their work. Second, occasionally a district judge will become kind of the gold standard on a particular legal issue. One example would be the work of a district judge who issued 5 opinions on e-discovery called the Zubolaki cases. Those carry great weight because her work is considered the gold standard. And third, if you have a situation that's factually identical to the situation you're dealing with, even if you're in a higher court, that can carry significant weight. I've argued cases where both I and opposing counsel more or less ignored some district court opinions, but in oral argument we realized very quickly that the Court of Appeals was very interested in these district court opinions because they dealt with identical issues. So district court opinions are rare. They don't always carry very much weight, but in certain circumstances they can surprise you. The Intermediate Court of Appeals is really the bread and butter of constructing legal arguments. They issue written opinions in nearly every case, and they hear many more cases than the United States Supreme Court. In my practice, for example, I cite a lot of cases from the United States Supreme Court, but I cite many more from the Intermediate Courts of Appeals. Within the Intermediate Courts of Appeals, there exists a sub-hierarchy of 3 layers of precedent that are created based on 2 important distinctions: published versus unpublished opinions, and panel opinions versus en banc opinions. The first distinction, published versus unpublished, is not meaningful in every jurisdiction. Some states, for example, don't recognize such a distinction. But in the federal system, it becomes very important because a published opinion is binding on the court itself as well as courts below it. For example, the Fifth Circuit Court of Appeals, where I practice, applies something called the rule of orderliness, under which every published panel opinion binds every other 3-judge panel that might consider that issue in a subsequent case. By contrast, an unpublished opinion does not implicate the rule of orderliness and also is persuasive on the lower courts. The second distinction, a panel opinion versus en banc opinion, is also very important. Every case is randomly applied in the Court of Appeals to a 3-judge panel to decide it. But once that 3-judge panel decides the case, if it chooses to do so in a published opinion, that's the law for every future 3-judge panel under the rule we just described. The only way a Court of Appeals can overturn its own precedent then is by sitting en banc, or as an entire court, to reconsider the issue. If it does, it can overrule its own precedent because it's no longer bound by the rule of orderliness. So if we were to kind of summarize these 3 layers, this sub-hierarchy within the Court of Appeals, the most powerful precedent would be an en banc opinion, which to my knowledge are always published. The second would be a published panel opinion, and then finally an unpublished panel opinion. If you have a Supreme Court opinion that's on point, then that's the law. But be careful, because the Supreme Court likes to issue narrow opinions and let the lower courts work out the details. The Supreme Court is also fairly mindful of only reaching the question presented and leaving the other related questions for another day. So whenever you're dealing with a Supreme Court opinion, read it very carefully, including the footnotes, so you're clear about what exactly is being decided and what's being reserved for another day. Also, if you're dealing with a plurality opinion, make sure you understand that the narrowest ground controls under the rule of Marx versus United States. The relationship between state and federal court opinions is complex and depends largely on the area of the law in discussion. In my experience, federal courts don't care very much about how state courts have resolved certain legal issues until you get to one crucial question, which is how a state is interpreting its own law. In fact, in instances where a state court is interpreting state law, that can become binding on federal courts dealing with that same question. In the criminal context, we see this, for example, in Mathis versus United States. In the civil context, famously in the Erie line of cases. But be careful, because the same nuances that we've described within the federal court system also exist within the state court system. So whether you're dealing with a Mathis issue or an Erie issue, the federal court's going to be much more likely to consider an opinion from the highest state court binding than it will a lower state court. When considering the use of books, treatises, and restatements, it really depends on the source. What you have to do is read judicial opinions and observe which of these materials are being treated authoritatively. Some examples that the Supreme Court traditionally have considered authoritative are dictionaries. Other books like Wright and Miller's Federal Practice and Procedure. Certain restatements, but not all, for example, contracts, torts, foreign relations law have all been considered authoritative by the U.S. Supreme Court. And then most recently, a book by Scalia and Garner called Reading Law, which is kind of a textualist approach to statutory interpretation, has been appearing more and more often in written opinions. As a person who has written and enjoys writing law review articles, I hate to say it, but they carry very little weight in a legal argument. They can be a wonderful resource for getting a quick sense of what an area of the law entails, what are the contemporary issues. And although the U.S. Supreme Court, in a healthy minority of its cases, does cite at least one law review article, I rarely see such citations within the Intermediate Court of Appeals. So today we've constructed a vertical hierarchy of precedent that you can use when thinking about your legal arguments. Of course, there are certain topics we didn't address today, such as a distinction between holdings and dicta, also a distinction between analogous facts and distinguishable facts. These are very important distinctions that we'll address in a later video. I would also like to thank a Twitter friend of mine, Rafi Melkonian, who's a very skilled attorney, who made a Twitter post that inspired the video that I've made today. I hope you've gotten something out of it.